And now it's time for another case law update. Today's update covers Illinois National Insurance Company versus Harman International Industries, Inc., an insurance dispute between Harman and 3 of its insurers, which was recently decided by the Delaware Supreme Court. Here's what happened. In 2017, Samsung acquired Harman through a merger. In response, a group of former Harman shareholders filed a lawsuit alleging violations of federal securities laws, claiming they did not receive enough information to make an informed vote on the merger. Harman settled with the shareholders for $28 million. However, Harman's insurers denied coverage of the settlement amount, claiming a bump-up provision excluded the settlement from Harman's policy. The insurers claimed that the bump-up provision excluded coverage of the settlement amount for 2 reasons. The claim underlying the settlement alleged inadequate deal consideration for an acquisition, and the settlement amount represented an increase in deal consideration. What is inadequate deal consideration? Inadequate deal consideration refers to a situation where the price offered in a transaction, such as a merger, acquisition, or asset transfer, is insufficient or unfair in relation to the value of the entity or assets being acquired. An increase in deal consideration occurs when the value offered to shareholders in exchange for their interests in a transaction is enhanced. The trial court concluded the settlement amount did not represent an effective increase in deal consideration and concluded the $28 million was covered by Harman's policy. The insurers appealed. The issue on appeal was whether the $28 million settlement constituted an increase in deal consideration and was therefore excluded by the bump-up provision. The insurers argued 2 claims. First, the bump-up provision required only that a claim allege inadequate consideration. And second, when determining an increase in deal consideration, the court must look toward the overall result of the settlement, rather than whether the settlement was for the actual purpose of increasing the deal consideration. In response, Harman argued the bump-up provision did not apply because the settlement amount did not represent an increase in deal consideration, as the settlement amount rose from a securities claim that Harman deprived the shareholders of the ability to cast an informed vote on the merger, rather than from an increase in deal consideration. The court held that the bump-up provision did not exclude the settlement amount from the policy's coverage. When analyzing the bump-up provision, the analysis required 2 steps. First, determining whether the underlying claim alleged inadequate deal consideration, and if so, whether the settlement amount represented an increase in that consideration. Both requirements had to be met for the bump-up provision to apply. First, the court found that the shareholders claimed they were deprived of their full value of their shares due to inadequate information from Harman, and that was sufficient to satisfy the first step. With the first step of the analysis complete, the court then considered whether the settlement amount represented an effective increase in deal consideration. The court held that the insurers failed to meet this step. The court explained that the overall settlement class included shareholders who did not receive deal consideration, and there was no evidence, such as expert reports, that calculated the true value of the shareholders' loss within the settlement negotiations. Thus, because neither party knew the true value of the shares, no one could calculate the potential enhancement the shareholders received. The court concluded that the settlement amount likely reflected the cost of avoiding further litigation rather than enhancing the share value. In conclusion, the Delaware Supreme Court affirmed the trial court's judgment, holding that the bump-up provision did not preclude coverage of the $28 million settlement. The court found that while the underlying claim alleged inadequate consideration, the insurers failed to prove that the settlement represented an increase in deal consideration. So why does this matter? When you are litigating, there's a lot going on. If you expect your settlement to be covered by insurance, you must understand exactly what your policy includes and what it excludes, and draft your settlement accordingly. This responsibility usually falls on in-house counsel, who is monitoring your litigation. If you don't have in-house counsel, RRNA offers an effective solution for monitoring your litigation and making sure that your settlement fits within the coverage of your insurance policy. That's all for today. I'd like to thank Frances Warden, a law clerk in our Denver office, for her help on this update.